Good evening. My name is Rajneesh Tyagi. Welcome to our show, which is mainly focused on financial matters. Financial matters which are related to your day to day life. If you have any uh, debt problems, if you are struggling with your credit cards, store cards, loans, any invoice outstanding, any HMRC tax debt liability, if you have, then you can give us a call on our direct studio number, and one of our advisor will be then in touch with you. Uh, in today's segment, I'm going to discuss about uh, people who are struggling to pay their debts, or we can call them a vulnerable client if they have any health issues, terminal illness, or long term uh, illness, and if they are unable to work, or uh, any other reasons because of age also sometime, and they do have a lot of debt still outstanding, unsecured debt, then under the law, under the FCA debt solution laws, there are chances that under a vulnerable client category, their debt can be written off. So if at a certain age, if you are even a young person also and you have some terminal illness and long-term illness, as I said, and any reason that you are currently not able to work because of your health issues or family issues, and you have a higher level of debt size, then first part is that you can request your creditors to write off your remaining balance on any account. If you have any credit cards or loan balance, then the first thing which you can do is write to your creditors explaining them that these are the following reasons, possibly your medical reasons, your family reasons, your health reasons, and maybe the age also, or you are currently retired and you are on a state pension and you have difficulty, you don't have any disposable income. Explaining those reasons, and possibly your creditors will consider this and will write back to you. Possibly they might ask for some more proof about your health, about your medical reports, but eventually, if you will write to them, you may seek a debt advice, or you can ask an expert, and they can also help you in gaining some more knowledge about how you can write up your detailed summary letter to your creditors and request them to write off your credit card balance or your personal loan or your store card or any other unsecured borrowings which you may have. Now, uh, sometime in case if you are you have any health worker or a care worker, then you can fill a form, you can get them to fill a form on your behalf, and your creditors will accept that also, that if your doctor or if your GP, your health worker, care worker is writing something on your behalf about your health, that letter will also give more evidence to your creditors about your health condition, about your medical report also. And then you can request your creditors to write off immediately your debt, so that you will not be liable to pay in coming years or months' time for the debt which you were paying in past. So there is a clear-cut law under CONC rules, under FCA rules, that if you are a vulnerable client, your creditors must deal with you with respect, and they will be sympathetic also about you. So they will not be forcing the way it used to be. They used to be difficult debt collection practices in past. They will be realistically sympathetic, and they will understand your situation and will write back to you. Possibly some lenders or some creditors may say that they will not take any action for the next 12 months, and after 12 months they are going to assess your situation again. Eventually, in case if your situation is long-term affected, if you have long-term illness, or you have uh, a reason that you are not able to work because of your age, or you are retired now, or any XYZ reasons, you are caring for someone also, Do take advice from a debt advisor, a qualified debt advisor. There is no harm in taking advice and getting appropriate and suitable letters out along with the appropriate documents so that your case can be presented in a right way with your creditors and these debts can be written off. So in today's program, it's very important that people who are struggling and are vulnerable clients, old clients, aged clients, um, or people who are on the bed because of their sickness, they are not able to work, but they do receive letters and calls every day from their creditors who normally demand their money. Then this is the way moving forward. Always seek an advice in case if you're not sure, and so that you will not be having a lengthy letter correspondence with your creditors, because if you're writing something, and if there are any areas where your creditors can question, then they will write back to you and they will ask or demand more proof. So one part is the request side, and so you can request your creditors, and then you can you can request them to write off all your debts. So that's one part. The second part, which is a legally binding part on the creditor side, is also that if you have no assets, if your debt size is high, but you are currently not working and not in the position to repay any monthly installment to your creditors, then you can declare yourself bankrupt. That's called voluntary bankruptcy. Instead of creditors taking action against you and making you bankrupt, you can declare yourself bankrupt, because if you feel that you are not going to work, or you are at a certain age, or you have some sickness, long-term sickness also, then you can declare yourself bankrupt, so that your debt legally will be written off and your creditors will not be able to take any action. The first part was the request base, where you will be requesting your creditors, and then it's their discretion whether they accept that request. But there is no harm in case if you have grounds where you can show that you are a vulnerable client. There are specific grounds under conc rules of FCA, under debt management laws, and your creditors normally accept those, and then they can write off your debt. Bankruptcy is the second solution. £685 is bankruptcy fees to declare yourself bankrupt. If you are on a certain benefits, if you are receiving job seeker allowance, or if you are on certain other benefits, then you may be entitled to get waiver in the bankruptcy fees. So you can ask, in case if you're planning to declare yourself bankrupt because of a mounting or higher level of debt size you have, unsecured debt if you have, then you can declare yourself bankrupt also. That's more legally binding, and your creditors will have to write off all your debts. Normally, once you declare yourself bankrupt, after 12 months under bankruptcy, you can be discharged from the bankruptcy. So then you can again start your banking. You can again start opening up your bank accounts, and then eventually in coming years, then you will be able to apply for a basic credit facility also. So that's something which is under bankruptcy you can do. Or in case if you don't want to go for a bankruptcy route, then there is a cheaper route or lower fees route, which we call is debt relief order. If your debt is, say, less than £20,000, and if your overall disposable income is not more than £50, then and you have no assets also. The third part is that you have no assets more than £1,000, then you can declare yourself under a DRO order also, debt relief order, and that's also something. £90 is the fees for debt relief order. You can write off your debt under debt relief order also. These routes are applicable in England and Wales. Scotland has different routes, which are sequestration, or Scottish bankruptcy we call it, protected trust deeds, and minimal assets process MAP. So these are three routes to reduce or avoid your debts, or So these routes are in Scotland. So if you are living in England and Wales and you want to inquire about some other debt solutions, you have some queries, you can give us a call on our live studio number, and I'm happy to take the call, and then we'll try to answer any queries you may have. Now, as I said in the beginning, that if you are not sure, you want advice how to write off your debts, you please seek an advice. You can take independent advice from various firms. There are some charity organizations also in UK, Citizen Advice Bureau, National Debt Lines. If you feel that you want immediate advice, you can always seek an advice from Citizen Advice Bureau. But if you wanted to seek a personalized advice or an advice from a professional firm, commercial firm, who are into debt solutions and offering range of debt solutions, you can then speak to them as well. Normally, there is no fees for a consultation, and fees will be outlined once your debt solution plan is finalized. Then your debt advisor or a debt management company is going to tell you in advance how much fees will be for managing all your debt solution plans. Now, also in today's program, I'm going to discuss about statutory bar accounts also. There are, sometimes we do receive calls or sometimes people do inquire that, their debt is a bit old and they took some loans 10 years ago, 12 years ago, 15 years ago, and can these be written off? Legally, can these be written off? Normally, people do say that, after 6 years, they feel that, debt will be written off, but that's not the case. Your default notice remains on your credit report for 6 years from the day when it was registered, but your debt normally continue, and you need to maintain your monthly installment, and you need to pay off your debt. There are few ways. There are few solutions for debt, how to pay your debts. One is debt management plan, individual voluntary arrangement, bankruptcy, full and final settlements or partial settlements, and or, as I said, that if you're a vulnerable client, you can request voluntary and you can write off your debt with your creditors. Now, in today's program, I'm going to discuss some rules under the Limitation Act in UK. Limitation Act in UK allows you to legally write off your debts. In case if you have had any debt and there is no correspondence from your side to your creditor in last 6 years, and your creditors also have not chased you, then under the law, under the Limitation Act, your creditors will not continue to pursue the debt for a longer time, because the law allows that they can only pursue the case if there is certain time. So if you have not received any communication from your creditors and you also have not chased your creditors in last 6 years, and there is no payment which you have made, then under the law you can request under the Limitation Act that your creditor should write off the debt and they should not chase the debt. Now, how this works, I'm going to discuss that also, and how Limitation Act works. That's very important, that how it works. Now, Limitation Act normally would be when you have, say for example, if you have written something to your creditor in last 6 years and you admitted and you signed it, and you wanted to inquire some balance on your particular account, then that is something that you have agreed that there is a debt liability, so that will not be counted. If you had 6 years of break from your creditors and they have not chased you, there is not any letter from the creditors, and you have also not replied to them even via email or via any written correspondence, then your debt can be written off under the Limitation Act. So that's normally called statutory barred. Statutory barred accounts cannot be enforced in the courts also. So in case if you receive any county court judgment or any county court claim form then we must see that can this account be under a preview of statutory bar account. So if the Limitation Act works your on your account because you believe that your credit agreement was signed more than 6 years ago and there is no correspondence from your creditor in last 6 years, and you have also not contacted your creditors for any inquiries on the account, then that Limitation Act can work on. Some creditors still, they do take a chance and they try to make a claim, and they try to enforce the debt. In case if you believe that there is a claim against you and your creditor have issued an N9 form, and then in that case you have the duty, or what you should do is that you need to challenge that claim form. You should seek an appropriate advice, a legal advice. Possibly you can also consult with your debt advisor and then write up your detailed defense, explaining that there is a Limitation Act onto this account, and in order to get that information, there is a chance that you can get some more information from the claimant, from the creditor, by requesting your SAR report, subject access report. So via subject access report, you will have all the data from the date when the account was initiated and the account was open. If it is a credit card account, or if it is a loan account or a store card account, if any of your creditor is going through a claim form or they want to enforce the debt in the courts, then make sure that do not leave the account or try not to ignore that claim form, because if you ignore claim form, then it is likely that the judgment will come against you, or you will be then liable to pay. Once there is a judgment from the court, then the Limitation Act will have no power. So ensure that once there is a claim form, that has to be defended in a good time, in a reasonable time. There are 14 days time by law. Within 14 days time, you need to submit either your acknowledgement of service or your defense, so that your defense and counterclaim, if there is any counterclaim, can be logged into the court systems, and then judge has to take a decision, and possibly there will be a hearing also, and then judge is going to decide whether on your defense points, on the merits of your defense points, whether the judge can decide that this should be now written off. So it's very important that Limitation Act, because this is something legally binding, your creditors are bound to write off your debt. In case if you believe that your debt was really, really old and there are no correspondence, then best is to use Limitation Act and make your account statutory barred, so that your creditor will not choose to send you any further reminders or any letters also. For credit card, store card, personal loans, any type of unsecured debts, the Limitation Act period is 6 years. For other debt liabilities like HMRC, there is no limit. In case if there is any HMRC debt liability, older liability, 10, 12, 30 years also, there is no time limit. So Limitation Act doesn't work in HMRC tax debt. Even in council tax debt also, the limit time is 20 years. So if you have had any council tax arrears and your council is not chasing you from last many years, they have up to 20 years time to chase you, or possibly send you any letter or demand any response from you in order to enforce the debt further. But if it is a credit card, personal loan, store card, or any bank loans or any overdraft accounts, then the maximum limit of a limitation on an account is 6 years. So that's one thing which you should be aware of. Also, this program is also dedicated for business debts also. So in case if you have any business debt, VAT outstanding, self-assessment, your PAY arrears, then, and if your business is struggling now, you are not able to pay your bills, business liabilities have risen up, and there are less income now in the business, and you're planning to wind up your company, and you believe that you have given some personal guarantees also on your on your business loans and now you're worried, then please seek an advice. There are ways, there are solutions. Personal guarantees in some cases can be challenged also. So if you have given personal guarantees on a business loan, on a limited company, and you're a company director or a sole trader even, then you can, your debt advisor can prepare your defense, and your personal guarantees can be challenged in order to ensure that your personal liability on the business loan can be avoided. Because what happens if you have given a personal guarantee on any business loans, then the first liability comes for that loan repayment is from your business. So till the time your business is up and running and your business is able to maintain the monthly installment, then that's absolutely fine. But if you're planning to wind up your company and your business activities have reduced because of any XYZ reasons, if you believe that there's a lot of competition now in your business, or there is less income now, or sometime UK economy, Brexit, a lot of other external, internal reasons, trade reasons also. If your business is now struggling and you have given personal guarantees, so ensure that your personal guarantees can be challenged in certain cases. So do take advice on your business debts also. But if you do have rent arrears and you are now receiving some enforcement action, possibly a bailiff action also, or some claim forms from the court, please do not ignore those. Although in recent time, bailiff, when the bailiff visits, there are certain laws, there are certain ways how bailiff can enforce and can claim the money. So automatically bailiffs cannot enter into your premises to collect the goods from your premises. There are certain laws now so in case if you want to seek any advice, please do seek your advice about your rights when the bailiff visits your property. But try to avoid county court judgments, because bailiff can only enter into your premises when there is a judgment against you. So ensure when there is a claim form, when there is a court form, when you receive, if you are into business also or a personal debt. Oh, we got a caller. Hello.
Hello.
Good evening. Hi.
Yeah, I want to ask, do you have any product for the people who got mortgage, interest-only mortgage?
Oh, you are currently on an interest-only mortgage.
Yeah.
And how many years term you have, sir, left on your mortgage?
3 years, 3.5 years.
3.5 years left now. How old are you, sir?
I'm 68.
You are 68, so you would be 71 when you're. And how much outstanding you have on the mortgage?
It's £232,000.
232. Are you currently working?
Yeah.
Okay. Because there is a limited time in this program, after this program, I'm going to have a detailed discussion with you, possibly either today or tomorrow, and we will discuss. There are ways we can, or possibly, I need to assess your case, or one of our mortgage advisor in our office would assess your case, and then possibly, we would be able to better give you advice once the full assessment has taken place.
Okay.
Okay.
Are we at work tomorrow?
Yes, surely we will be. One of our team member will be in touch. We'll try to find the right time when we can contact you.
The phone during the work. Only can answer the call between 12 and 1.
Yeah, surely we can write an email to you, and we can come back to you with the right time.
Yeah. Okay.
But there is a possibility, sir, if you are 67, and if your term is going to end in 3 years' time, you still have a mortgage outstanding. There are ways we need to see whether you are still working and till what age you are going to work. So those parameters has to be taken into account, and then an application can be put forward to your lender so that your term can be extended, and we can find the ways how you are going to repay your mortgage.
Okay.
Okay. We'll come back soon on this.
Yeah.
Thank you for your call.
Thank you. Bye.
Okay. So any financial matters, if you are under pressure, if you feel that there are some loans, credit cards, store cards, mortgage issues, if you have, you are now at a retirement age, but you still have a huge outstanding on your credit card, personal loan, and you are worried, then do not worry. There are debt solutions available. There are suitable debt solutions as per your needs. Speak up, give us a call on our live studio number, and possibly we'll try to find the solution. Um, Also, I'm going to discuss. So, in today's program, my focus was to give, you know, uh, uh, information on vulnerable clients, people who are, uh, on a terminal illness, if they have a long-term illness, also if they are not fit, if they have mental health issues, if they have any conditions, family conditions that they are not allowed to work or they are not able to work. And so a debt advisor can assess your situation, whether you fall into a vulnerable client category. In case if that happens, then there are ways that your debt can be completely written off. I have evidenced those cases that I have, worked in such cases where the debt size of even 180, 185,000 pound, 190,000 pound was written off because the client was in a vulnerable client category. So there is no harm. It's, although as I said that it's discretionary on the creditors, but there are some legally binding solutions also. So I want to give peace of mind to our vulnerable clients who are aged, who are ill, and who are struggling with their mental health issues, or if you are any other family issues which makes you under a vulnerable client category, then a debt advisor can help you and possibly can prepare your case summary and can present your case to your respective creditors so that your debt can be legally written off. I always say, do not let debt trouble your life. Live happily and ensure that debts, whatever debts you have, are the matter of past, and focus in your future, focus on your work, focus on your family life. Any mortgage worries if you are planning to switch your mortgage because you are currently on a standard variable rate, and you want to inquire something about that also, some basic information if you want to inquire, quick information if you want, please do give us a call on our live studio number, and I'm happy to help here. If you are a single parent and you need help, you are on a low income, if you want to maximize your income by gaining or by getting some UK benefits, you don't know where to start, what benefits you are entitled to, how you can maximize your income, then also do give us a call so that a thorough assessment can be done how your income, overall monthly income, can be maximized. There are families who even are not claiming even child benefit or other benefits also, housing benefits. They don't know, and they are working. They are doing hard work, but they are not sure how they can maximize their income. They should give us a call so that an assessment, a full assessment on your benefit entitlement can also be done. Also, in today's program, I am going to discuss about some debt solutions which can help you. Some tips also I can give you. One, before I give you some debt tips, one is that in case if you already have a debt size, if you have a debt size of approximately 5,000 pound or more, and now you're struggling, you know that if you're paying any monthly installment on your credit cards or store cards, that money is being eaten up by your creditors, by your banks. So a very small portion of that money is going to reduce your debt liability, and you keep paying your monthly installment, and you cannot see end of your debt worries. If that's the case, then possibly one of the debt solution would be recommended to you, and I would advise to seek a debt advice. But if you go for a debt advice, then there are three potential benefits which you will have. One is that you will pay what you can comfortably afford. Second would be that your creditors will not harass you any further. They will not give you a call. Third thing, debt management plans normally aim to freeze all interest and charges on your credit cards or store cards or personal loans or overdraft accounts or your any invoice outstanding also. So interest and charges you can expect that will be frozen on your accounts. The third benefit is that because you have defaulted your payment in past, you were not in the position to pay your creditors the contractual payments, and once you are under a debt management plan, then you will pay what you can comfortably afford. So your monthly payment under a debt management plan will not be defaulted henceforth. So you will have a peace of mind. You will pay what you can comfortably afford, so that you can focus on your work. You're paying your bills also on time. So if you do have any queries, I know a lot of our viewers are not aware about debt solutions. They don't know if there is any particular solutions which can help them in gaining control on their finances. Do speak and give us a call on our uh, live studio number. You can even check it online about some debt solution plan. And so in today's program, I hope that you liked the program. I would see you next week, same time, Wednesday at 8:30. Uh, Thank you very much for joining us, and my special thank to the one of our viewers who has called up today. And thank you. See you next week. Bye bye.